The government of Kenya has continued to cooperate with the court from the beginning. How else did the prosecutor ever come to Kenya? Ocampo came to Kenya. Do you remember that? He was not escorted by a UN convoy. He was invited by the government of the Republic of Kenya, given diplomatic protection, came to Kenya, spoke to the president, spoke to the prime minister, spoke to everybody he wanted, and then went to the Nairobi Park and adopted a cheetah. Is that what you call, is that what you would call non-cooperation? The ICC came to Kenya and established permanent offices. They have permanent offices in Kenya. They have permanent staff in Kenya, traveling throughout Kenya daily. Is that non-cooperation? When Fatou Bensouda became the prosecutor, we facilitated for her to come again and meet the president, meet the prime minister, and talk to all the people who she needed to talk to. Is that non-cooperation? We have complied with them. When, without being members or without being party to the case, the prosecutor continued at public lectures and forums like this one to insist we had not cooperated, I filed an application to the court and I said, we are not required to file anything here. But because it is said we don't cooperate, please allow us to appear in this case limited to demonstrating that we are cooperating. And the court agreed. If you ask me, I do not know of any other country in the world that has assisted this court in the manner that we have assisted. I do not know of any other country in the world. And I am waiting with bated breath. The other day I read that the court has opened an inquiry in the attack of the flotilla by Israel. I'm waiting with bated breath to see the level of cooperation. I'm still waiting for the court to tell us when it will open the file on Syria, or on Egypt, or on Libya, or on Guantanamo Bay, yeah, or on drone strikes in Pakistan and Afghanistan and Iraq. So that there is a double standard here that, to my mind, as a lawyer and as an African, I find absolutely unwarranted.
Some of that information has yet to be received. We have not received it up to now. Now, as the Attorney General has indicated, he has filed an application in the court. We have responded to that. So all we are saying is not anything that we are inventing. It is something that is concrete. It is something that is out there in the public filing. So when we talk about cooperation, we are not referring to public pronouncements of cooperation. Cooperation must be tangible, it must be concrete, it must be timely for it to be meaningful for our work. The reality about the cases in Kenya is that all our evidence, everything that we need, is in Kenya. And some of it is actually in the hands of the government of Kenya. Without the cooperation of the government of Kenya, without the government of Kenya facilitating us receiving that information, we cannot call that cooperation. We cannot call that cooperation.
We were told witnesses had been taken to Europe, all the documents were available, all we needed was to start the case. That narrative was abandoned about a year ago, and now there is a new one that says there is no evidence available now because the Kenya government is sitting on it. That to me comes as a great shock, because this is a case that was taken to court and persons were confirmed to have, that the court said it was looking at reasonable evidence. Where did the evidence go? The case must have been confirmed because there was evidence. An argument that now says the Kenya government is sitting on the main evidence we need to get on with the case either says the case was never ready from the beginning, as the Belgian judge who recused herself from the case last week said, this case was never ready from the beginning, or this case ought never to have been brought from the beginning. Any prosecutor who opens a file does so because he's looking at evidence. Any prosecutor who takes it to the chamber for confirmation does so because he has evidence. Any prosecutor who says, give me a hearing date for my case, does so because they have evidence. To then turn around and say, the reason we are not moving is because the evidence is with the Kenya government, to my mind, is outright unprofessional.
The issue being that since the prosecutor spoke to the president and the cabinet subcommittee and outlined the outstanding requests, those requests have up to now not been forwarded to the court. That's the fact. That is what we are stating in our filing to the judges. Those outstanding requests, which are crucial for our case, still remain outstanding.
They said to me, witnesses are being intimidated. Witnesses are being threatened. And I said to them, where are the witnesses so I may protect them? They turn around to me and say, we cannot tell you that, of course, you know that. We can't tell you. I am guilty of not protecting witnesses whose names I will not be given because they are not safe with me, but I am guilty of not protecting them in any event. How more ridiculous would that be?
He has made his point to the judges. We have made our points to the judges. He has indicated the number of things that the government of Kenya has done. We agree with that. We are very grateful for what the government of Kenya has done. But all we are saying is that there are still issues that remain outstanding for which we expect the government of Kenya to comply with.
This is not a political discussion between two politicians. It is a legal argument between two lawyers about what the law says. And we have now submitted ourselves to the judges of the court to tell us who is right and who is wrong. Who is the injured party? It is we who are the injured party because all these things have been said, they have taken root, the media believes it, and now the public believes it because we had never been given an opportunity to state our position. Our position is this. Everything that the prosecutor is entitled to under the law, we have given. Everything she has requested, which our reading of the law tells us she is not entitled to without a court order, we have asked her to go to court and bring the court order. A charge that would hold would be if the prosecutor was saying, the court told you to give us the file relating to X, and it gave you 10 days to do it. You have not done it. Then she can say, you are not cooperating. But when two lawyers are arguing about a legal point, none of the legal argument is superior to another until the judge has made a determination.